My lord,
May I be permitted to mention, my lord? I'm from the appellant insurance company, and this is Workman compensation case and application for stay.
my lord, may I have your lordship's kind leave to mention a group 6. It's a hearing matter, my lord.
Hearing matter.
The hearing matter. My lord, may I just indicate the predicament of the petitioner? Petitioner is the mother of a minor daughter, my lord. From 2022, she is not getting her salary, my lord. The Honorable Single Bench directed the state to pay arrear salary, my lord. They have preferred an appeal. They have not paid a single penny, my lord. The stay application has been dismissed, my lord. Dismissed, my lord. But my lord, the appeal is pending, my lord. Affidavit
have you filed a contempt petition?
She is not in a position to file a contempt, my lord. She is hand to mouth now, my lord. 2022, she is not getting. Since 2022,
All right, you give.
So great.
But you have to inform the other side.
My lord, there is a cross appeal, so 2 appeals will be appearing simultaneously, my lord.
You put them on notice.
So great.
Your Lordship, I crave leave to mention a matter occurring virtually, Your Lordship.
Yes.
Your Lordship, in these matters, the assessee has opted for the VSV scheme. So therefore, Your Lordship, we would have to withdraw those appeals for the purposes of further proceeding in the matter. My junior, Your Lordship.
Yes, you give the numbers, we list it.
I'm grateful. I apologize for appearing virtually, Your Lordship.
No. Most welcome.
I'm grateful, Your Lordship.
Yes. Yes.
Review application, it was supposed to come on 20th June, Lordship.
Review.
Matter. Yes, Lordship.
It's a review or an appeal?
Review application. Order sheet to dewa.
Yes, please call.
Original side daily list, item number 1.
No, this is for withdrawal, my lord. We have gone for the VSP scheme. But the letter instruction from the clients are here, my lord.
Please take down. This is an appeal filed by the assessee under section 260 capital A of the Income Tax Act 1961 within bracket the Act, challenging the order dated February 7, 2024, passed by the Income Tax Appellate Tribunal B Bench, Calcutta, in ITA number 48/KOL/2023 for the assessment year 2019-20. The learned advocate appearing for the appellant assessee has placed before us the written instructions given by their client, stating that the assessee has availed the direct tax Vivad Se Viswas scheme and requests that the appeal be withdrawn. In the said letter given by dated 28th June 2025, along with copy of Form 2 and the challan is placed on record, and the appeal stands dismissed as withdrawn on the ground that the appellant assessee has availed the benefit of the direct tax Vivad Se Viswas scheme. Consequently, the substantial questions of law suggested are left open.
I'm grateful, man.
New application tax matters, item number 2.
Served, madam.
So,
Your Lordship, in item number 2, Your Lordship, I've been instructed to appear. There is one issue that we faced, my Lord. While serving us with a brief, Your Lordship, my learned friend has by mistake given us the papers pertaining to IT 134 and not ITA 130, Your Lordship. And so, Your Lordship, we do not even know the delay. And I would also have to, after looking at the papers, advise my client whether he should opt for VSV or should continue with the appeal. So, humbly praying that a correct copy be given.
That you serve the copy.
I have served. If he has not copy, I will provide him.
No.
But it is wrong. It is wrong that has been given, my lord. Only the correct. He's given us by mistake ITA 134 and not 130. The letter is of ITA 130, but the document is of ITA 134, your lordship.
All right.
He may give it to my junior, your lordship, and I'll take instructions in the matter, my lord.
All right. We have heard Mr. Amit Sharma, learned advocate appearing for the appellant department. Mr. Pritish Jhunjhunwala accepts notice for the respondent assessee. Let copy of the appeal, the stay petition, as well as the application.
My lord, I have served. I have handed.
The copy of the stay petition and the application have been served on the learned advocate appearing for the respondent who seeks time to get instruction in the matter. List next week.
My lord, delay
My
160.
lord, I may have to take instructions in the matter. I'm grateful, Your Lordship.
Yes.
I don't know, 3.
Your Lordship, this appeal is connected to 3 other appeals that is being argued by Mr. Kundalia and Mr. Bhonjo. Your Lordship had heard those appeals on Wednesday and was pleased to keep it on 9th, the next Wednesday.
So this can go along with that.
This can go along with it.
This Casta 25 of 2025 to be listed with so and so on 9th.
Your Lordship, I'm led by Mr. Kundalia and Mr. Bhonjo. Grateful.
For admission of tax matters, item number 3.
But I'm appearing in this. But the,
Item number 4.
but the questions is, my lord, whether the reopening was made on the basis of a borrowed satisfaction or that was the question, my lord. If so, my lord, Lordship will kindly come to straight away, my lord, the CIT's observation, my lord. If your Lordship will kindly come to, my lord, CIT's order was CIT appeals order starts at, my lord, page number 42. I'm relying page number 45, paragraph 4.1. I have gone through the facts of the case of the appeal, the submission made by the appellant during the appeal proceedings and the circumstances of the case. As regards the grounds of appeal, there are 2 major grievances. One against the reopening under section 147 Act and the additions made by the learned assessing officer on account of bogus purchase under section 69. The brief facts is that that it has been found by the investigation wing that the department that Mrs. Sancheti Diamond Limited is a bogus company where there are dummy directors having no credit worthiness. The department, the statement of Sri Vijay R. Rathore was recorded where he could not justify that the huge volume of transaction appearing in the bank account to the extent of rupees 3.85.75 crores. The field inquiry and the verification showed there was no business activity carried out from the Surat address of Sancheti Diamonds, and there was no stock available. The dummy directors could not prove the transaction details of the materials purchased and even could not explain that the question the jurisdiction related to the diamond business. Even the Mumbai office of the Sancheti Diamonds did not show any business activity. Thus, though the bank account displays the volume of transaction, but there were no supporting evidences regarding the same on the ground. The quantum of transactions did not match with the income profile of the accessee and appears to be exist on papers only. It is on the basis of that information that the case of the appellant reopened and the purchase of rupees such and such from Sancheti Diamond, though the appellant claims that the purchases are genuine purchases, but could not establish that the genuine assessing officer, and the AO has added back the total. The first question regarding reopening of 147 is that observe that the case has been reopened after recording the reasons from taking prior approval from under section 151 of the Act from the appropriate authority. The notice issued and served through the registered post. There is no issue in respect to the date on which the notice of 148 of the Act shall serve. AO in the assessment order has clearly mentioned that the objections of the assessee regarding the 148 reopening was duly displayed before passing the speaking order. That is, this means that the objections regarding 148 reopening was disposed of before passing of the order. On perusal of the statement order shows that the AO has extracted the relevant part of the reasons recorded in page number 17 of the order. The recording of the reason shows that there is definitely and information in the possession of the assessing officer that indicates that the affairs of one of the suppliers of the appellant, that is Sancheti Diamond Private, were not in order and were apparently fictitious. The aforesaid findings were based on the inquiry and investigations by the investigation wing and the field inquiry. Since the appellant assessee has made substantial purchases from the suspicious entry, therefore the assessing officer had reasons to believe that the income escaped assessment. Thereafter, within the limitation prescribed by the Act, AO after recording the reasons of belief the escapement of income took the prior approval of the concerned authority and issued the valid notice. Therefore, there is no infirmity in reopening the cases and the initiation of the proceeding under section 148. It is relevant to mention that the assessing officer has reasons to believe that the sufficiency of the reasons cannot be questioned. During the original proceedings, the unsubscribed bogus purchases was not disclosed by the appellant, and there has been failure on the part of the appellant to make fully and truly disclosures of, and it has been held by the various judgments that the mere production of books of accounts or not non-constitute full and true disclosure of the assessee has come to material conclusion that the intentions kept under wraps, that the appellant has failed to make the full and true disclosure at the time of original assessment. Therefore, the present reopening was made assessment order after due recording the reasons and proper approval valid reopening of the assessment upheld. The assessing officer has mentioned about the accounts number such and such with Mumbai Opera House branch and took the total deposit of rupees amounting to rupees 385.75 crores, out of which the 380.60 are debited through transfer. The large volume of transactions are suspicious. The company Sancheti Diamond does not have any sound financial base, and it shows that the mere profit against the huge sell. In addition to that, the inquiry reveals that it had a dummy director with there is nothing on business activity in the field. Thus, that is apparently the affairs of the entity from which the purchases are made are not clean. Thus, the conclusions that the purchases are fictitious. The assessee also, during the assessment procedure, could not prove the transactions have actually happened in reality. These transactions appear to be make-believe transactions in bogus purchases. In the absence of any direct evidences, the assessing officer, on the basis of a preponderance of probability, held that the transaction is not genuine and relied upon decision of Honorable Court in the case of Sumati Dayal, and he also relied upon the CIT versus Durga Prasad More on the basis of above mentioned judgments. He held that the conclusion that the claim of the assessee to the above mentioned is absurd and bereft of credibility. The appellant is not real. He is also relied upon on the decisions of the Honorable Delhi High Court in CIT versus Nova Promoters and Finances, wherein he could held that the evidences adduced by the assessee has to be examined, but superficially, but in depth, having regard to the test of human probability and in the normal course of human conduct. In the present case, the assessee could not prove beyond doubt the suspicious nature of the purchases affected from the suspicious supplier whose creditworthiness is extremely doubtful. The assessing officers also relied upon the decision of ITAT Kolkata in Bisaka Sales Private Limited and held that the assessee knows that in the intricacies of the account, he has to prove merely dumping of papers of documents could not be sufficient. And this is the finding of the CIT appeal mirror. Then therefore, thus giving the above reasons, the assessing officer found that the creditworthiness of the supplier is doubtful and affairs of the assessee is not in order. Therefore, the treated on the basis of the circumstances, the expenditure claimed to purchase of rupees 2 crore 69 lakhs and odd from the Sancheti Diamonds is bogus and added back to the total income of the assessee. During the assessment proceeding, the appellant has not been able to demonstrate anything beyond the paper documents to show that the purchases were genuine. The investigation report cannot be trusted in the soul when he's done painstaking inquiries, and it has been held that the judgment in Calcutta High Court in the case Swati Bajaj, that it appears that so Milord, he is of the opinion that Milord, he's a dummy company, so he could not explain anything. Therefore, Milord, it is not a borrowed satisfaction, it is own satisfaction. On the basis of that, reopening has been done. Milord, this is I'm showing Milord CIT's observation. Now, Milord, if your Lordship will kindly see, Milord, the tribunal's observation. That is, Milord, tribunal's order starts at page number 48. Milord, if your Lordship straight away come to Milord, page number 59. We have heard the rival submission and carefully perused the material on record. The assessee has raised the common legal issue challenging the validity of the reopening of the assessment for the assessment years 11, 12, 12, 13, 13, 14. We know that the assessee is a private limited company engaged in the business of purchase and sale of diamonds for the past many years. The books of accounts are regularly audited and audited financial statements were uploaded on the websites of the Income Tax Department as well as the Ministry of Corporate Affairs. The assessee is also registered with the Value Added Tax Department and has been regularly filing returns and also being assessed under the VAT authorities from time to time. Regular returns for the assessment year 11, 12, 12 to 13, 14 were filed on such and such date, respectively. The reopening for the assessment year 11, 12 has been carried out after 4 years, but the returns of the assessment 11, 12 were processed under 143 on the Act and no scrutiny proceedings were undertaken. So far as the assessment year 12, 13, 13, 14 is concerned, the original returns were selected for scrutiny and the assessment under section 143 of the Act was framed on 31st of March 15 and 15th of March 16. The copies of the assessment orders were such and such were placed on record, suggests that the assessee had furnished reply to each and every query raised by the assessing officer in the questionnaires, and the books of accounts were produced and the business transactions, including the purchase and sales, have been examined and by the AO to the extent. The reasons recorded by reopening of all these years are similar, and though we have already reproduce the reasons in the preceding para, we deem it for appropriate once again reproduce the same. The information received from that the Sancheti, that reasons we have stated, that the Sancheti Diamonds Private Limited Company, such and such Mumbai, having PAN number, the account was reopened on such and such date of incorporation of the company is 2007. The account has triggered a very high value of non-cash transactions in the current account as per the information about the bank official, the customs, the gem jewelry transactions patterns shows that the accounts get credit mainly by RTGS transfer and get debited by clearing by the RTGS and the transfer. The total amount of deposits are total 385.76 crores, out of which 380.60 crores are debited through transfer. Large number of non-cash transactions in the accounts seems to have been unusual and it raises a suspicion. Sancheti Private Limited is engaged in the trading of diamonds and gold jewelry. On perusal of the financials of Sancheti Diamond Limited, it is noticed that the company Sancheti Diamonds Limited have not have sound financials and has shown meager profits against the large sales for the assessment year 10, 11, 12, 30 to 12, 30. The company has shown a profit of rupees only 50,985 and rupees 2,97,95,000 against the total turnover of rupees. Well, this is a lordship. He has shown only profit to the extent of 50,000 and 2,97,000. Total turnover of rupees 323.67 crores and 177.04 crores. It appears that the directors are dummy directors only who have no creditworthiness. During the investigation proceedings, summons were also the directors were issued to Director Vijay R. Rathore. My lord, his submissions were recorded and the statements were recorded. In the statement, he asked to state the sales of stocks and the books of accounts mentioned in Surat office such and such. My lord, however, on field inquiry and my lord, inspector was reported that the business activity is carried out from the Surat address and no stock is maintained there. Further, Sri Vijay Rathore was also asked to produce the transportations details of the material purchased, but he could not provide. But he was also asked to many questions. The director asked many questions, but he could not satisfy the department. He could not produce any documents to show that this was actual transaction. He merely is in his profits and account, but he's showing 50,000, but transactions were done to the crores, 350 crores and 177 crores. Thereafter, he has also asked many questions in the diamond business, but he could not satisfy the explain. From the statements, reflect the Mumbai office, the company such and such is found that carried out a transaction. Though Mrs. Sancheti Diamonds Private Limited has replied that the credits of the banks is against the sales, however, no supporting evidences have been produced by the assessee company to justify the credits in the bank accounts. The transaction in the bank account does not much with the with the income profile of the assessee, the match with the income profile of the assessee, considering the facts and circumstances, it appears that the company is not engaged with any genuine business activity and they exist on only paper. On perusal of the back statement of recovers of Ms. Sanchita Diamonds Private Limited, it is noticed that the following parties pertaining to the year judicial have entered made purchases from Mrs. Sanchita Diamonds Private Limited, which are suspicious and needs verification. Further, on perusal of the of the financials of Purple Suppliers Limited in the SSC the company has poor financial. It shows the either nil outcome loss of a mere amount against the huge turnover. This huge turnover does not match with the financial profile and seems suspicious. Every year, the huge credits and debits are outstanding, which further seems suspicious. Both the registered address of the returns of the SSC of the company are in Kolkata, but directors are based in Mumbai. From the perusal of the above reasons, we find the reopening proceedings have been initiated based on the information received from the investigating wing, Mumbai, in the case of SDPL, which is engaged in trading diamonds and gold jewelries. Based on the poor financial of SDPL, where the profits declared are too meager in comparison to the huge turnover, and in the statement of Mr. Vinod Kumar Rathod has accepted that he is engaged in providing accommodation entry. Investigation wing Mumbai observed Mr. SDPL is to be an accommodation entry provider. This is also important. It is also observed that the investigation wing of Mr. SDPL has issued sale bills of various companies, entities, since the SSC company has also purchased goods from Ms. SDPL during the impugned 3 years. The reasons were recorded by the assessing officer for reopening, carrying out the reassessment proceeding. As per the provision of Section 147 Act for the valid reopening limited, AO should have reasons to believe that and not mere reasons to suspect. Now, the common question before us as to whether the reasons recorded are in the nature of a reason to suspect or reason to believe. That the SSC in the present case is filing regular return or furnishing audited financial accounts, though the returns for the assessment 11-12 has been processed under Section 141. However, the audited financial statements are very much available in the income tax records. And for the remaining 2 assessment years, 12-13, 13-14, the scrutiny proceedings have been carried out, and the transaction declared in the financial statement have been scrutinized. The following chart giving the complete details of ITR processing, total purchase sales and purchase sale of SDPL report is under. But here chart has been shown, Purple Supplies. Before, the learned counsel of the SSC also referred to the retraction statement of Mr. Vijay Kumar Rathod, which is placed on page number 72-74. The affidavit dated 14/5/2017. The original statement where Vijay Kumar Rathod accepted to be indulged in providing accommodation entry were recorded on 14/1/2017 and 17/1/2017. But in less than a month, on 14/5/2017, Mr. C. Vijay Rathod filed an affidavit retracting the contents and statements made on 14/1/2017 and 17/1/2017, stating that he was under tremendous stress and trauma and was not in a proper state of mind and was without sleep and proper food. He has further stated that the statements was dictated by the officer in charge of the survey, and the said statement was not out of free volitions, and the same was also out of a tiredness and fatigue, stress. Now we find that now next paragraph 14. Now we find the very basis of the reopening mentioned in the reasons recorded the statement of Vijay Kumar Rathod on 14/1/2017 and 17/1/2017, and the impact of the statement was totally been nullified by the affidavit filed by Mr. Rathod on 14/5/2017. Now, without the support of the statements that was left with the assessing officer, was that the informations of the investigation wings about the poor financials of SDPL, even though the SDPL, which is a private limited company, is duly assessed with the direct and indirect taxes department, and they have also been scrutinized in regular course, but still the only fact which would raise concern was about the meager profits against the huge turnover. But from the details received by the assessing officer, the SSC from investigation being the member before the reopening the assessment proceeding has to first form a belief of the escapement income that there is a failure on the part of the SSE to discharge all materials, figures, and regular return of income filed by the SSE. But this could be figured only if the assessing officer makes a proper application of mind. On examining the transaction of the SSE with the available records, and then come to the conclusions that the material information has not been submitted by the SSE in the return and give rise to escapement of income. However, in the instant case, these additions which were made by the learning assessing officer should have been carried out are totally missing. It is clearly discernible from the fact that the assessing officer has only made the additions for bogus purchases. It seems that the moment information from the investigation was received, the assessing officer has recorded the reasons and carried out the reassessment proceedings without making any verification, simply made by the additions disallowing the purchases made by the assessing officer from SDPL, treating as a bogus purchase. In this regard, the assessing officer even forgot to note the present SSE apart from making purchases from Mrs. SDPL has also made purchase sales to SDPL for the assessment year 11, 12, 12 to 12, 13, which has been accepted by the assessing officer for the assessment year 11, 12, where the alleged purchases from SDPL to the tune of rupees 2 crore 16 lakhs, the sales of rupees SDPL are almost 100 times at rupees 254 crores. Similarly, for the assessment year 12-13, against the purchase of SDPL at rupees 141.5 crore against the sale of SDPL appear approximately 4.69 crores. It is surprising to note that in the case of the assessing officer examine the transaction between the SSE and SDPL, why has he raised doubt about the sales to Messrs. SDPL? So doubt about the purchase, the transactions with SDPL, but fully accepted the sales of to Mrs. SDPL. The fact is itself makes the picture very clear that the reopening has been carried out based only on the borrowed satisfaction. But this is the conclusion of the ITAT. But my lord, my humble submission, my lord, that
no, but the tribunal, what it says is
yes,
this come to
here therefore no, yes,
come to page 64.
64, yes, 64, yes, Amazon.
It is seen that the moment information from the investigation thing was received,
yes,
AO in haste recorded the reasons and carried out the reassessment without making any verification, simply made the addition disallowing the purchases made by the SSE from SDPA, treating them to be bogus purchases. In haste, the assessing officer even forgot to know that the present SSE, apart from making purchase from SDPL, has also made sales to SDPL for the assessment year 11, 12 and 12, 13, which has been accepted by the AO.
Yes.
For year 11, 12, where alleged purchases from SDPL is 2 crores and odd, the sales to SDPL are almost 100 times, 254. Similarly, the 12, 13, against the purchase of SDPL at 141.55, sales to SDPL are approximately 4.9. It is surprising to note in the case AO had examined the transaction between the SSE and SDPL, why he has raised doubt only about the purchase transaction with SDPL, but
Yes.
fully accepted the sales to SDPL.
But my lord,
The reason was that SDPL had a very meager
yes.
profit.
Yes.
That's the
And
only
also the statement of Mr. Vijay Rathore, my lord, the director, subsequently it was retracted, my lord.
within a month it was retracted.
Yes, within the month.
But both the assessing officer as well as the CITA does not speak about the retraction. See, every retraction will not make the statement as inadmissible. But the officer has to deal with that.
Yes.
Why he says the retraction is not acceptable. But I think there is no finding
No,
on
no,
the
so
statement.
far as yes, it is not there. It is not there.
Then you come to
If your lordship wants to see the assessment,
Page 76, para 18.
page 76, yes. Yes. Para 18. Now, in the light of the above judgment and the decision, and also considering the facts of the case, we observe that only the purchase transaction has been yes, doubted by the assessing officer, but the sale transactions of the company SDPL has not been accepted, has been accepted, and the profit arising thereon has been taxed. Yes. Now we know that even though the assessing event will the return was not selected for scrutiny, but still the reopening proceedings has been carried out. After a span of almost 5.5 years, the assessing officer failed to refer to the material evidences for the material facts which the assessee failed to disclose in the regular returns of the income. The proviso of Section 147 the Act provides that if any income, the chargeable tax in the case of the assessee has escaped assessment for the assessment year, so the assessing officer may, subject to the provision of Section 148 to 153, assess or reassess such income, or recompute the loss of and the depreciation of the disallowance of any other allowance or deductions for such assessment year. Therefore, the section and in the Section 143 referred to as the case in the assessment years. Now, for the purpose of carrying out the reassessment proceeding beyond the period of 4 days, regular assessment, yes, and to the 143, one of the important aspect is that there has to be a failure on the part of the assessee to fully disclose all the material facts for the assessment. In the present case, for the 3 impugned years, the assessee has actually fully disclosed all the material facts and the transactions of the purchases and sales, and they have also passed through the proceedings to proceedings of the assessment 11-12 and assessment proceeding 143 for 12-13 and 13-14, and the transactions, the purchases and sales have been accepted by the revenue authorities for these 3 years. In the in the case of an assessee, consistent view has been taken by the revenue authorities accepting the business transactions of the assessee. Before carrying out the reassessment proceeding, the AO has failed to find out the assessee has not disclosed fully and truly all the material facts. The reassessment proceedings have been carried out in a very poor foundation. This is borrowed satisfaction. There is, in the form of informations from the investigation being that too on a given scenario that where the statements recorded before the survey team by the key person of Mrs. SDPL has been retracted. This brings to the firm conclusions that the assessing officer has carried out the reassessment proceedings merely on the basis of borrower satisfaction. Reasons to suspect is merely change of opinion, and therefore the reopening of the assessment proceeding cannot be held to be valid in the eye of law. That is,
you come to page 27.
Yes.
The reasons for reopening purely on suspicion.
Yes. Page 20.
That uses the word suspicion in more than one place.
Yes. That the information received from Mrs. Sanchiti Limited, that the
last line of first paragraph.
Last line.
Large value of non-cash transaction in the
Yes.
seems to be unusual and raises suspicion.
Yes.
Then last paragraph of the reasons, third line. Huge turnover does not match the financial profile and seems suspicious.
Yes.
Every year, huge creditors and debtors are outstanding, which further raise suspicious. So, what Supreme Court says is reason to believe and not reason to suspect. Yes, sir. What do you like?
The reasons talk about suspicion and that require that the transactions require verification. There is no allegation of escapement of income. And the tribunal has also said that assessment at 12-13, that was a scrutiny assessment. So after 4 years, the notice was issued after 4 years. So the allegation of failure to disclose fully and truly all material facts, even that was not there. And of course, it's completely half-baked because all my sales have been accepted, not just the sales to these people, the
others also.
Entire sales have been accepted. So that part of the finding of
the only reason he says is for suspicion is that this SDPL, there is no business activity in the Surat address. The
showing very
very meager income. And their directors are all fictitious directors. On what basis? Because the assessment order, they have cooperated. They have furnished all the details, but there is no discussion on those details. he has in fact scanned those
Yes,
details and made it part of the assessment order.
but I'm having the brief from assessment at 12:13. There, the assessing officer made an inquiry from Surat, from Sancheti, and they confirmed the transaction in course of this assessment.
The next matter, 12:30.
That is not.
Please give.
I'll just check with.
IT 85. Next matter, 12:30.
That is 84 is 11:12.
Yes.
'85 is 12:13.
Page 19, if my lords are pleased.
19.
Yes.
19.
At the top, he writes that in course of. My lord has found it.
Same letter. Page 19, same letter. The same letter was there earlier.
In fact, the same is also available in IT-80.
Yes, yes.
4, page 19, same page 19.
Same page 19. 84.
Page 18 bottom. In the course of
Yes,
proceedings to verify the transaction with so and so, letter notice 133-6 issued to Sancheti to furnish information. In response, confirmatory reply was received, enclosing the documents, account statement,
Same.
relevant pages.
If my lords are pleased to see page 25, it is a part of the accounts of Sancheti. Annexure 6.
Yes.
First, kindly similar deposit with Gujarat VAT, then VAT refund Gujarat. The 21. So the tribunal has mentioned that they are assessed to both indirect and direct taxes. So this balance sheet shows that there was a refund that they had claimed from the VAT authority. So the
But if according to the AO, it was an irrational transaction, then sales also should have been irrational.
Yes.
If you doubt the purchases, you have to doubt the sales also.
Yes.
And for all the 3 years, it was a scrutiny assessment.
first year was 143.1. No? The next 2 years was scrutiny. Tribunal has noticed that.
That is 12-13 and 13-14.
Yes.
Those are the two scrutiny years.
Yes.
So 11-12 intimation has been received. So please come. IT 80, 84, 85, 86 of 2025. All the three appeals have been filed by the revenue under section 260 capital A of the Income Tax Act 1961, challenging the common order passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket Tribunal in IDA number 757/7 to 759 P/KOL/2024 for the assessment years 2011-12, 12-13 and 13-14. Since the facts and circumstances in all the three appeals are identical and the correctness of the order passed by the learned tribunal, which is a common order, is challenged in all the three appeals, they were heard analogously and are disposed of by this common judgment and order. The substantial questions of law suggested by the revenue are also identical, and therefore IT 84 of 2025 is taken as the lead case, which relates to the assessment year 2011-12. The revenue has raised the following substantial questions of law. Page number 4, A, B, C not required. Page 5, D, E not required. F, G, H not required. We have heard so and so. The assessee filed the appeals before the learned tribunal for all the three assessment years, challenging the order passed by the Commission of Income Tax Appeals, NFAC Delhi, dated 3/11/2022, arising out of separate assessment orders under section 143 within bracket 3, read with section 147 of the Act, passed by the Assistant Commissioner of Income Tax, Circle 5 within bracket 1, Kolkata, dated 31/12/2018. The first aspect which was considered by the tribunal as well as by us is with regard to the validity of the reopening of the assessment for all the years, all the 3 years. It is seen that insofar as the assessment years 2012-13 and assessment year 2013-14, the assessments were scrutiny assessments under section 143 within bracket 3, which were also reopened. The assessee is a private limited company engaged in the wholesale business of jewelry and diamond. The return of income was filed for all the 3 assessment years, and for the assessment year 2011-12, the same was processed under section 143 within bracket 1 of the Act. And for the other 2 years, namely AY 2012-13 and 2013-14, they were selected for scrutiny and assessments were framed under section 143 within bracket 3 of the Act. It appears that the assessing officer received information from the investigation wing, Mumbai, about suspicious business activities of Messrs. Sanchetti Diamonds Private Limited, hereinafter referred to as Sanchetti, which was having huge turnover but declared meager profit, and there was no proper business premises, and the key person of Sanchetti had given a statement wherein he is alleged to have accepted to be engaged in providing of entries of bogus purchases. It further appears that the investigation wing stated that the assessee company has entered into transaction of purchase of goods from Sanchetti during the 3 assessment years, and this led to issuance of notice under section 148 of the Act for reopening the assessments. The reasons for reopening were furnished, and the assessee submitted their objection, and the objections were disposed of by a speaking order. Thereafter, the reassessment proceedings were taken and they were completed, making addition under section 69 capital C of the Act on the ground of bogus purchases from Sanchetti. The assessee preferred appeal before the CIT within bracket A, but the same was dismissed by order dated 3/11/2022. Challenging the assessee preferred appeals before the learned tribunal, which have been allowed by the impugned order. As mentioned above, the first ground to be considered is the validity of the reopening of the assessment proceedings. And if the assessee is to succeed on the said ground, the question of examining the merits of the case would not arise. What is important to know is that the assessing officer has only disputed the genuineness of the purchases, but has accepted the sale transactions entered into with Sanchetti and others, and has noted the sale figures, which clearly indicate that the assessee had business activities. The question would be whether the assessing officer had reason to believe that income has escaped assessment on account of the failure of the assessee to fully and truly disclose all relevant particulars for the purpose of assessment. For this purpose, we are required to examine the reasons for reopening, which were communicated to the assessee. On carefully going through the reasons, we find that the assessing officer raised suspicion by alleging that large value of non-cash transactions in the account seems to be unusual and raises suspicion. Further, it was alleged the huge turnover does not match with the financial profile and seems suspicious. And for every year, huge creditors and debtors are outstanding. Huge credits and debts are outstanding, which also further raises suspicion. The Honorable Supreme Court in Lakmani Bevaldas 1976-103 ITR 437 within bracket SC held that the word contained in the statute is reason to believe and not reason to suspect. Suspicion of the assessing officer towards possible escapement would not permit to reopen a completed assessment in defiance of the statutory requirement of substantial nature. If the assessing officer did not have reason to believe that income has escaped assessment on account of failure on the part of the assessee to fully and truly disclose all the material particulars for the assessment, comma, the reopening could not have been done, that too based on suspicion. The learned tribunal has elaborately examined the factual position and found that after receipt of the report from the investigation wing, the assessing officer has to first form a belief about the escapement of income and that there is a failure on the part of the assessee to disclose all material facts in the regular return of income filed by it. The learned tribunal also found that the assessing officer, without proper application of mind, and without examining the transactions of the assessee with the available records, had come to a conclusion that income has escaped assessment tax merely on the basis of suspicion. The learned tribunal noted that the assessee, apart from making purchases from Sanchetti, has also made sales to Sanchetti for the assessment years 2011-12 and 2012-13, which has been accepted by the assessing officer. The purchases for the assessment year during the assessment year 2011-12 from Sanchetti is rupees 2, 69, 76, 121, and the sales to Sanchetti was almost 100 times at rupees 254, 32, 99, 846. Similarly, for the assessment year 2012-13, purchases from Sanchetti was rupees 141.55 crores and sales to Sanchetti was approximately rupees 4.969 crores. Though the assessing officer examined these transactions between the assessee and Sanchetti, curiously enough, doubt has been raised only with regard to the purchase transactions with Sanchetti, while fully accepting the sales to not only to Sanchetti but to other companies and entities as well. Therefore, the learned tribunal was justified in holding that the reopening was carried out based on borrowed satisfaction, a mere change of opinion. In Gakka Saran and Sons Private Limited versus ITO 1981 130 ITR page 1 within bracket AC. This is page 68 of the state petitions. I marked it here. It has been held that two distinct conditions must be satisfied before the assessing officer can assume jurisdiction to issue notice under section 147 of the Act. Full stop. First, he must have reason to believe that the income of the assessee has escaped assessment. Full stop. The important words in the said section 147 within bracket A are within inverted comma has reason to believe inverted comma close, and these words are stronger than the words inverted comma is satisfied inverted comma close. Full stop. The belief entertained by the assessing officer must not be arbitrary or irrational. Full stop. it must be reasonable, or in other words, it must be based on reasons which are relevant and material. Though the court cannot investigate into the adequacy or sufficiency of the reasons which have weighed with the assessing officer in coming to the belief, the court can certainly examine whether the reasons are relevant and have a bearing on the matter in regard to which he is required to entertain the belief before he can issue a notice under section 147 within bracket 1. Full stop. It was further held if there is no rational and intelligible nexus between the reasons and the belief, so that, on such reasons, no one properly instructed on facts and law could reasonably entertain the belief, the conclusion would be inescapable that the assessing officer could not have reason to believe that any part of the assessee's income has escaped assessment. It was further held that reason to believe, postulates a foundation based on information and a belief based on reason. After a foundation based on information is made, there still must be some reason which should warrant the holding of a belief that income chargeable to tax has escaped income. It is not in dispute that for all the 3 assessment years, the assessee has fully disclosed all material facts and the transactions of sales, purchases and sales. And in respect of 2 assessment years, namely 2012-13 and 2013-14, assessment proceeding scrutiny assessment was done under section 143 within bracket 3 of the Act. It is also not in dispute that the transactions dispute that in such scrutiny assessments, the revenue has accepted the purchases and sales for those 2 years. This would go to show that the revenue did not dispute the business transactions of the assessee. A statement said to have been recorded from the key person of Sancheti appears to have been the sole basis for issuance of the notice for reopening. The said statement has been retracted by the deponent within less than a month, and neither the assessing officer nor the CITA has dealt with the effect of the retraction. The learned tribunal has considered this aspect and has pointed out that the said person had filed an affidavit retracting the contents of the statement made on 14/1/2017 and 17/1/2017, stating that he was under tremendous stress and trauma and was not in a proper state of mind and was without sleep and proper food, and that the statement was dictated by the officer in charge of the survey and the statement was not out of his free volition, and the same was also out of tiredness, fatigue, and stress. It is no doubt true that all that statement, a retraction, is not always automatically accepted. But once a retraction has been made, the concerned authority who seeks to rely upon the statement has to deal with the retraction and examine as to whether the retraction was valid, and despite the retraction, whether the original statements can be relied upon. The order passed by the assessing officer as well as the CITA are absolutely silent on this aspect. Thus, the learned tribunal, thus we therefore we have no hesitation to hold that the reassessment proceedings initiated reassessment proceedings for all the three assessment years 2011-12, 2012-13 and 2013-14 are not valid. For the above reasons, the appeals are dismissed and the substantial questions of law are answered against them. I'm grateful. Grateful. Let's.
Appellate side, daily list, serial number 1.
So I am for the applicant in this matter. Well, I have filed this recalling application for the purpose of recalling the order of 16th of June 2025. This is my affidavit of service. My lord, initial petition, my lord, has been initially the writ application was moved under Group 7, coming under transport and communication. It was disposed of on 22nd of September 2000. My lord, 23rd of September 2022. Thereafter, after 2 years, my lord, the Union of India preferred one appeal, projecting it to be coming under Group C, Industrial Regulations matter. And when the matter came up for hearing before the division bench, my lord, the Honorable Court given liberty to the Union of India to correct the cause title and to correct the presentation form to be so that it is in proper manner. But it was again, my lord, stated that it's a Group 6 matter. And it came up before your lordship, and there was a delay of above 529 days, which was not indicated.
Oh.
And
what did we do?
Lordship's order is at page 27. It's actually a transport and communication matter.
We admitted the appeal and granted interview. And who appeared for the appellant?
Amrita Pandey, my lord, for that.
I am appearing for the appellant.
She is online.
Well, I have included all the status report of the Honorable High Court. Lordship, it will demonstrates. Lordship, kindly see page 13 first. This notice was issued, my lord, stating that it's coming under Group 7 when the petition was initially moved.
1 second. Which is your application? Can
3.
Yes.
Lordship, kindly see the last 3 lines, first 3 lines. It's Group 7 motion. Page 13.
Yes, group 7.
Yes. Then you kindly see the status, page 20, which I have obtained. Just under heading history of case hearing, Lordship kindly see it's group motion group 7, page 20.
Motion group 7.
Group 7. Now, Lordship kindly see page 22 when they preferred the appeal.
Yes.
Kindly see it's projected as group 3.
Where, which?
Yes, page 22.
Bottom 6. Group.
Yes, initially it was filed under group 3, then group 6. Now, my lord, kindly see the order of the ordinary honorable division bench again, my lord, at page 19. They were given a liberty to correct the presentation form. Then again they said that it's a group 6 matter, which is nowhere related with this present application. Group page 19. Proper group was not indicated.
No, what according to you is the proper group?
Group 7. And there is a special designated bench of this honorable court. Code was also given wrong. This is the presentation form, my lord, which they have annexed.
And where is the advocate Sheikh?
And there is a delay of 529 days, my lord, without indicating that lordship appeal has been admitted. And no service has been effected upon us. The advocate on record is present here for the writ petitioner. No service has been effected upon us. And reliance has been made upon a coordinate division bench's order. That has become infructuous because that person has already left the contract prior to the filing of that appeal. And reference was taken of that order so that the same can be made applicable here also.
Yes, madam.
Your Lordship, in this matter, I was not at the trial stage in the writ petition, so I did not know under what group
But then
this was filed.
it's a group 7 matter because the matter came before the division bench and you are granted permission to amend the presentation form. But once again, you filed this appeal under group 3.
Your Lordship,
Group 6.
Group 6. Which is service related matters, my lord.
Now, in this presentation form,
It's group initially group 3, then again they have made it as group 6.
Actually, it should be group 7.
7.
Your writ petition was filed
Group
on
7.
7.
Status report is also showing it's group 7.
That
and
is concerning railways.
Now it
And
has been.
There was a delay of 500 days. That was not.
Your Lordship, on the date when the matter was taken up, I did not appear on that date, Your Lordship. So,
All right. This application has been filed Can 3 of 2025 by the respondent in this appeal, praying for recalling the order dated 16/2/2025, by which the appeal was admitted and an interim order was passed. It is pointed out that initially they pointed out that the matter concerns group 7 classification, and it has been wrongly classified by the appellant as group 6. And this aspect was noted by the division bench on an earlier occasion, and the matter was released. Apart from that, it is pointed out that there is inordinate delay in filing the appeal, which appears to have not been brought to the notice of this court. Since the matter relates to group 7, this court did not have determination to deal with the matter. Hence, the order dated 16/6/2025 is recalled, and MAT 668 of 2024 along with Can 1 of 2024 and Can 2 of 2024 shall be listed before the Honorable Division Bench dealing with Group 7 matters.
and Your Lordship, leave may be granted to correct the Form A.
The
This
learned
has been
advocate
done
for the
my lord,
appellate.
to prevent
It
us
has been
from
done, your lordship,
taking part in the
inadvertently,
proceedings.
your lordship,
Pardon?
and not as
Prevented us from taking part in the proceedings so that we could not be heard.
And you say, sir, notice has not been.
No copy
lordship,
has been
on
served upon
that
us.
day, none appeared for the
records. The learned advocate on record for the appellate.
This type of
is
should be
permitted to
deprecated, my lord. This is
carry out the correction in the presentation form.
Union of India, my lord, is appearing. Could have understood.
It is an
Private individual is
All right,
mistake, your lordship.
Recall,
I
recall.
apologize.
Yes,
for that.
next.
grateful, man.
I am for the response, but I beg to appear on behalf of the state.
Whereas I beg to appear on behalf of the applicant.
The mentality of this application.
In this application, the petitioner seeking only clarification, my lord. There is no dispute or any wrong in the order itself. At least I did not find it. But
Which application you are now arguing? Can
Can too.
can too.
Can too.
And my lord, the
Can.
appellant opposite party, my lord, is using your lordship's order as weapon, by which I can restrain to perform my puja only.
Paragraph 6 and 7, Lordship has clarified the entire clarification.
Lord, kindly-
Here B and C is not maintainable, and this is a type of review is in form of modification
No,
application. Yes. My lord, the civil dispute should be adjudicated with the civil court. Lordship has clarified that. And paragraph 6, kindly come to page 104, Lordship's order.
আরে আমার petition আমায় বলতে দাও।
তোর কোনো petition নেই।
Lord, kindly straight away come to page 100. Your lordship's order.
মামলা করছে এটাই কি অনেক নয়? দুটো করেছে তারপর মামলা করে
তবু চেঁচাচ্ছে দাদা।
আচ্ছা তাহলে করতে দিচ্ছি।
চুপ করে
তাহলে আইডিস ফিস করবো?
তুই একদম কথাই বলবি না।
বলবো। আমি চুপ করে বল।
Page
100 is your lordship's order. And the relevant page is from 103. English version. You know at page 104 from paragraph 6.
সেটাই বললাম। দেখো দেখো। আপনি দুটো করে এসছে।
Lord, again I am submitting, Lord, there is no perversity in the order. I am not challenging anything. Order is okay. But the other side is using this order as weapon to restrain me to perform my puja, which is
Absolutely false, my lord. This is 6 and 7, paragraph 6 and 7.
last.
আচ্ছা ঠিক আছে তুমি বলে নাও তা
Allow me to
ঠিক
submit.
আছে তুমি বলে নাও তা
No, we clarified that whatever observations were made was regarding to the 24th puja.
Yes.
And parties were at liberty to agitate the matter before the civil procedure.
I'm grateful.
Now, how are you misusing this order?
I don't know.
You know, last page
I don't know how can it be.
last
I
page I
just indicate two things, Miller.
They are
transferred-
trying to stop
is
my
related-
software which I am running the
Let
trade
me-
license in the name of this order.
May I be permitted to clarify the position for a moment? But the dispute as regards to the holding of a Durga Puja. According to the Mr. Dalapati's client, they are performing the Durga Puja in a different land. Now, Mr. Amitabh's client is saying that this Durga Puja is holding in my land. These two maujas, according to my understandings, are little different. Now they have approached before the single bench. Justice Chandra pleased to order that this will not be precluded to stop the minute the pujas. Puja will continue.
Yes.
Puja will continue and both the party will amicably participated in the puja. Now this is the order of the trial court. Challenging before that they have come up after the puja gets over. Lordship has restricted that this particular thing will be applicable to the 2024 only. Now this is they're facing the trouble possibly, as I understand. This case is that their case that they are performing the puja on a different mauja which is not belongs to Mr.
Yes.
applicant case. That is the case here. Now I have made an inquiry and I have furnished the report also to the Miller before the learned trial court. It shows that whatever the claim of the Miller, the petitioners of the Miller in the trial court,
is not substantiated. They are holding the puja in their different Durga Mandir, and Durga Mandap is there, which belongs to Mr. Dalapati's client. I have given the photographs and everything to the single judge. If your lordship so desire, I can come back and say, because this is not ready with me in the offhand. But apparently, Millard, these two puja,
before the single bench,
right?
The subdivisional officer submitted a report. Who submitted a report?
Millard, the police has submitted the report.
Police has submitted.
Mine.
My lord, may I submit, my lord, after his submission is complete? My lord, kindly have a look of these two documents. The first one is my trade license in respect where I am running the business. I am not standing on the way for the performing the puja.
We'll
say
that.
Absolutely. And civil dispute. আমি ভাই একটুখানি বলতে দে তুই সেক্রেটারি ভাই ওখানে যখন বলবি আমি বলবো না
Now, because of the puja, your shop room is closed.
No, not because of puja. What have they done, my lord? Kindly, the second document, there is the English translation, second document, the single page. The English document, which is their annexure. Also, my lord, my godown's electricity has been disconnected by them. My lord, what is the problem I am facing? My lord, regarding civil right, title, interest, civil code is there. Lordship has clearly observed in para 6 and 7 years of your lordship's order. I am not standing on the way to their puja. My lord, lordship has also observed that this order, writ court's order, single bench, honorable single bench order is constitute to the puja year 2020, which has happened. If they face any difficulties, they will approach either before the civil court or before the single bench, whatever they choose as per advice. If they face any problem, I am not creating any problem. They are creating problem to running my business.
He can record your submission that you are not objecting to the conduct of the puja. Yes. But you are aggrieved by some disconnection of.
Not disconnection. I am aggrieved by this puja. They will. একটুখানি আমি বলতে দে না ভাই
তো বল না কে তুই চুপ করে বল
my lord by this puja they will not obstruct my right to trade which I am running, my lord, by way of trade license issued by the competent authority.
That you should know.
My lord,
his
godown is just diagonally opposite to the temple of Durga Mandir. And my lord, kindly have a look into page 61.
Lordship, kindly see the photographs which starts from the page 59 onwards. Kindly have a look. This 59 shows there is a pakka structure where this Durga Puja is being held. Lordship sees the 59. Now, since after that, 61, these are the it appears to be the Durga Puja which is held on a regular basis. Yes. So Durga Muncho is over here. This performing of the Durga Puja is held over there only.
Yes.
So this is
where is this godown?
His action. Lordship would see on the page
57, my lord.
Page 57.
Page 57, the photograph is there. I can.
Opposite.
Two things. Lordship sees first page 57.
Not to close my godown, not to obstruct my business. They will perform their Durga Puja. I have no problem.
Well, I just
and my lord, police has submitted a report, my lord. My lord, may I submit with due respect to the my lord, concerned authority? My lord, the surveyor should be the measurement of Mouja and the Dag number. How the police will be come to that?
We have a right to make an inquiry to that extent. We have made the inquiry.
In respect of the tag number and the mouch number.
Would you please allow me to make something?
No, sir. I am not.
Allow, please. Kindly see the 57, page number 57.
Where is this shop?
This
shop just diagonally left hand side. Tall building.
Green.
Diagonally opposite.
Correct. This is the building.
How they can object?
I don't know, but
This is the road, sir. This
Yes.
photograph shows there is a road. On the left-hand side, there is the Durga Puja Pandal, which is a permanent structure.
Yes.
Though it may have a temporary roof. On the right side, you are doing business. See, normally what happens, it is a collective effort. People in the entire para, they will contribute, etc. So festivity will take place. Wait, sir. You keep on instructing him how he will be able to hear what.
Kindly do not take.
The problem is with all of you is you think you are above the deity. Close your puja then.
I tender my apology.
A council, when he makes submission, he should be able to hear what the court says. And the art of instructing a senior is a fine art. I don't know when you all learned that. So normally what happens, everybody contributes, there will be a club, there will be an association. There may be obstruction of traffic sometimes. They will cover the road, they'll have a pandal on top. And generally for that, it's not going to be year-long festival. How many days?
4 days, 5 days, 7 days, 10 days, 15 days, even since Mola. I am sportingly appreciate that.
So therefore, you also participate.
My lord, my lord, my lord. If it is
some ego is
no ego.
And Lord, he is my cousin brother. He is not my neighbor. He is cousin brother.
This photograph at page 57, we have got a color photograph.
Yes.
Your shop room is opposite the green building, which cannot be obstructed. But during the festival time, there may be people coming.
I will compromise that. I will compromise. I will record my submission. I will not standing way. I will compromise with that. But my lord,
similarly, when you organize the puja,
when the puja with the date,
should not be inconvenienced.
When the puja will be held, Mala kindly appreciate when the date of the puja and will he come with this application?
He is going to start on Saturday, tomorrow.
And tomorrow is the auspicious ceremony for clay giving to the idol. Clay giving ceremony is tomorrow.
Do it. For
you invite him also.
Yes, Lord, he is my cousin brother.
Do it.
Welcome.
Do it. For that reason, you cannot close my
you
godown.
Also come, please.
This application has been
don't stop my godown. Kindly clarify that. My business will not be affected.
This application has been filed for appropriate clarification of the judgment and order dated 7/4/2025 in FMA 137 of 2025. The said appeal was filed by the writ petitioner against the order dated 25th September 2024 in WPA 4382 of 2024. In the said writ petition, the applicant/appellant prayed for an order, prayed for issuance of a writ of mandamus to restrain the respondents from disturbing or interfering with the possession of the applicant/appellant in respect of the premises in question where they were to conduct Durga Puja. The appeal was disposed of by order dated 7/4/2025 and the operative portion of the order reads as follows. Please quote para 5, 6 and 7. It is in page 104 and 105. As could be seen from the observation made in the above order, the court did not venture into the merits of the matter, since by then the puja for the year 2024 has been completed, and therefore it was observed that the observations made by the learned single bench cannot be referred to or taken advantage for the puja for the year 2025 or for any subsequent years. The allegation of the applicant/appellant is that the private respondent, who is none other than is also related to the applicant, is objecting to the conduct of the puja by misinterpreting the observations made by this court in FMA number 137 of 2025. This allegation is emphatically denied by the learned advocate appearing for the private respondent. After we have elaborately heard the learned counsels for the applicant/appellant, private respondent, and the learned government counsel, it is clear that the question of obstruction of conducting the puja may not arise because the shop room of the private respondent is situated diagonally opposite to the puja pandal, which from the photograph we find is a permanent structure, but with a permanent structure and partially with a temporary roof. The learned advocate for the private respondent on instruction submits that the private respondent is not objecting to the conduct of the puja, but under the guise of conducting the puja, his business activity should not be hampered. From the photographs which have been filed along with the application, more particularly at page 57 and 62, it primarily appears that there cannot be any obstruction to the private respondent from carrying on his business activities in the shop room / godown. Since the private respondent has stated before this court that he will not object to the conduct of the puja for the year 2025, the said submission is placed on record, and the private respondent shall not object to the conduct of the Durga Puja. Likewise, the applicant / appellant also should ensure that the business activities of the private respondent, which is being conducted from a shop room / godown, should not be affected in any manner. In the event there is any other problem, any other difficulty which may be faced by the applicant / appellant or the private respondent, they are directed to approach the officer in charge, Salboni Police Station, District Paschim Medinipur, so that the matter can be resolved. With the above observations, the application stands disposed.
My lord, may I bring one in since there is no exchange of affidavit? My lord, no allegation is, my lord, we have,
the application is
and my lord, civil court will not influence by
calling for affidavits. The allegations made in the application are not deemed to have been admitted. And furthermore, any observations made in this order will not prejudice the parties before in the pending civil suit in TS number 414 of 2024 within bracket R.
Extremely good.
So you invite him, give him some uttara, you give
For
him
Durga Puja, nobody's invitation is required, my lord. We will voluntarily go there.
My lord, in place of appellant applicant, it will be private respondent applicant.
private applicant / private.
ওইটাই ভাবছিলাম ওই জায়গাটা প্রথম জায়গাটা একটু বোধহয় ডিফিকাল্টিস হবে
Okay, he was the writ petitioner.
Yes, he was the writ petitioner. He preferred the appeal.
So it should change.
My lord. And my lord, this order will not create any embargo.
এমবার্গো নয়
Sir, I mixed up.
বউকে এখন দেখি কোনো লাভ নেই সেটা তো হয়ে গেছে হয়ে গেছে মিটিং করে এসে মামলা করছে
মিটিংটা করে এসে মামলা করছে তাও তবু জোর চালাচ্ছে সন্ধ্যা না থাকলে আমি মরেই যেতাম দুটো থেকে 3:30 থেকে 9 থেকে বন্ধ এমনি 3:30 থেকে 9
Before your lordship takes up the next matter, I tender my unconditional apology. It was my mistake. It was my mistake.
Pressure was behind you. The person standing behind you, so you are trying to keep him cool.
Extremely grateful.
Otherwise, you lose track.
Yes.
Then he won't be able to respond to court's court may seek a clarification.
I tender my apology once again.
Grateful.
But I appear for the petition.
What was the error of law committed by the AO?
The error of law was that I am a composite dealer. A composite dealer enjoys the freedom of paying tax at a reduced rate under subsection 4 of section 18. And my lord, since I'm enjoying that privilege, my lord, the respondent authority did not have the jurisdiction to impose tax on me at the full rate. But that was the error of law, my lord. I challenged in the.
And as against the draft assessment, did you file your objection?
Yes, my lord, but that particular point was not taken in the objection. Yes. My lord, the client himself filed the objection, so he was not so much conversant of the provision.
And before the tribunal, you raised that issue?
I raised that point, my lord. I took that point, my lord. The assessing authority had no jurisdiction to impose tax at the full rate on me.
So the compounded rate of tax is 3%.
3%.
And what he imposed?
Well, 14.5%.
14.5.
Yes, at a certain part and 5% at another part.
But this could have been agitated before the appellate authority. But
well, basically, this is without jurisdiction of the assessing authority, my lord. He has no jurisdiction. Well, I have brought the judgments of this honorable court and the Supreme Court, my lord. It says that if it is without jurisdiction, the assessment order is without jurisdiction, my lord, that can be challenged.
That can be. And which is the document which shows that you fall under the composition scheme?
My lord, assessment order itself. My lord, kindly come to
page 23.
Kindly come to page 26, my lord.
26 is the final assessment.
26. My lord,
purchase.
The line starts in purchase, yes.
The dealer has filed return F15.
Form 15.
Dealer was in composition scheme and not entitled to any ITC.
Yes, madam. But I have not.
And where is the final assessment?
But this is the final assessment order, madam. And ultimately, on page 27, kindly see, he has taxed at a certain part of turnover at 5% and another part of turnover at
outward tax 14.5.
Yes, madam.
And outward tax 5%. But how does he say that in spite of you being under the composition scheme, this rate is leviable?
That is not applicable. That is a mistake he made, and that is the error of law I challenge, madam.
Why can't he raise it before if he is a composite dealer? Because once
again, my lord, these people are coming with this. This cannot be without jurisdiction or subject to correction, my lord.
No.
This is the
rate of tax.
Strategy appeal lies against it.
No, it is an admitted fact. The dealer has filed a return in form F15. F15, I think, should be an exclusive form for a person who has opted to be under the composition scheme.
Yes, madam.
The AO was aware of it. So he can't treat it as a normal return. We'll do one thing. We'll make this final assessment order as a show cause. He will give his objection regarding this rate of tax. And he will redo the assessment.
I will take all objections.
This writ petition has been filed challenging the order passed by the West Bengal Taxation Tribunal dated 4/9/2024 and RN 122 of 2024. The writ petitioner filed the said application before the learned tribunal challenging the draft assessment order as well as the final assessment order dated 21/2/2024 and 19/4/2024 on the ground that the appellant dealer having opted to be be under the composition scheme under the provisions of the West Bengal Value Added Tax Act 2003 could not have been taxed at a higher percentage more than 3%. The learned tribunal was of the view that the application is not maintainable before it, and the appellant and the writ petitioner should avail the remedy available under the Act by approaching the appellate authority. This observation made by the learned tribunal is undoubtedly correct. Nonetheless, the petitioner has raised an objection regarding the jurisdiction of the assessing officer to impose higher rate of tax, despite the fact that the petitioner is a dealer under the composition scheme. This aspect of the matter could be construed as one of the circumstances to bypass the statutory appellate remedy. We have perused the draft assessment order as well as the final assessment order, from which it is clear that the writ petitioner / dealer has filed return in form F15, and hence he is form 15, which is a form prescribed for dealers who have opted under the composition scheme. If that be so, the assessing officer ought to have considered this aspect of the matter. Though this point was not specifically pleaded by the writ petitioner while giving their objections to the draft assessment order, this being an issue touching upon the jurisdiction of the authority, we are of the view that the matter should be considered by the authority and fresh orders should be passed. For the above reason, the writ petition stands disposed of by directing the petitioner to treat the final assessment order dated 19/4/2024 in memo number 226 as a show cause notice / draft assessment order, and the writ petitioner is directed to file their objections within a period of 3 weeks from the date of receipt of the server copy of this order. On receipt of the objections, the assessing officer, namely the Deputy Commissioner Sales Tax, Barasat Charge, Barasat, shall consider the said objections and pass fresh orders on merits and in accordance with disposed of.
Grateful, madam.
This might serial number 4, my lord. Mr. Choraria is appearing for the applicant.
Who?
Mr. Sandeep Choraria. But he has some personal difficulty. He called me up. He called Mr. Chakraborty. So, Lordship, can he takes it up on next Thursday? He's not in town, my lord. He has some personal difficulty.
At the request made on behalf of the learned advocate for the writ petitioner next week.
It may please your lordship. My issue is, my lord, here.
We can't say his name. You tell the council council record name.
My lord, yes, both. My lord, the issue here, my lord, the writ petition only not entertained on the ground of the delay, but though the learned judge observed that there is a gross violation of principle of natural justice by the passing of the order by the respondent number 1 as well as respondent number 2, because the respondent number 1 passed the order on the basis of the report prepared by the respondent number 2, the Central Tax Authority. I served the copy to the Central Tax Authority, my lord. And that report was prepared without considering my single line of my submissions and relevant judgment which is governing the case. My case is, my lord, I am coming to the facts, but the issue is only they are disallowed my send back credit in the Tran 1 only on the ground that in the invoice it's not mentioning the registration of the service recipient to me. But law is that as per Rule 4 of the Central Service Tax Rule and Send-Back Credit Rules also, only the service provider, his name and its address and his registration number is required to mention. I will make the submission on the delay point because I have come before the Honorable Court within period of 3 years, because there is several judgments in Supreme Court. In one case, I find, my lord, set out the reasonable period 3 years, though there is no straitjacket formula, but only consider that whether it will prejudice to the other party or not. There is no question of prejudice to the other party because I am claiming my legitimate claim because it is the input in my hands. But at the transitional period, when the GST came, the unutilized service tax should be transferred to Tran 1. It is 2 crore 7 lakhs. I am demonstrating the facts, my lord. What is the facts here, my lord?
Why you took 3 years to come?
Actually, my lord, I have incurred the huge loss of 32 crores in Bengal in respect of this project, my lord. This is the erosion of my reserve and surplus. I can show from my financial accounts also. In the year 2004, for the first time, I get some amount by the reason of the order of the Kerala High Court. The award has been awarded, the arbitral awards there, they have challenged. After that, there is the order of the district court for attachment of their property. After that, on getting of the interim order, they are liable to pay 75 lakhs. Now 1.5 crores they have paid. After that, immediately that the management decided to file a writ petition because it is a legitimate claim. Before that, they are thinking that, my lord, I've already incurred 32 crores, my lord. It is not a 1 crore or 2 crores against this project. And only not for my laches, entirely for the laches of the state of West Bengal as well as the Keltron, that Kerala Electronics, that is one of the institution. Actually, what is the project, my lord? I am telling you, my lord. In the year 2017, the state government decided to lodge a project, this Amar Shahar, in order to give the e-service to the respective area. In the Birannagar municipality, there is citizens are there. They decided to do that. So it is the project of 71 crores. But one of the condition that until and unless it is live in Goan, it is not successful at all, then you cannot raise the bill. Initially the agreement with the Keltron, but there is an assignment clause. On the basis of the assignment clause, they have assigned to me. And after that, I have tendered to other local people also. That is a Smart Planet. They have committed some bricks wall, some bricks works, some computer and other things. This is 31.82 crores. And against that, I have immediately paid along with the service tax and VAT. After that, I immediately claim under the Tran 1, after there is a judgment of the Supreme Court, because there is some technical glitches in claiming Tran 1, then I claim it again. And what happened, my lord, in this case, because it is the relates to the service tax issue, that is why, but my adjudicating authority is state authority. So that is why they have to take the report from the state tax, central tax authority. And before the central tax authority, I have given entire detail twice, not one. And I have requested them, please give me an opportunity of hearing and not before preparation of the report. When they send the draft report to the state tax authority and it is communicated to me, again I communicated to them, please allow me, because it is the totally error, it is the beyond the law, because I am entitled for the reason which are giving to me, it is not sustainable at law. But they have not turned down by email, they have confirmed that no, that report is correct. On the basis of that, that state tax authority, because they don't have any expertization on that, only they merely accept their report, nothing more. And they have disallowed my claim. So against that, I have come immediately to the, after 2024, I immediately affirmed my petition, but it is at Kerala. But one unfortunate happened there, that after Puja vacation, I asked them to send it the notarized copy, but they misplaced it because there is a renovation work. But ultimately, they have found their petition in the month of January, and immediately I filed the petition. And this is within 3 years, it is within 2 years even, my lord. And when the Supreme Court says, my lord, that there is the legislative period is 3 years, then that single judge may have taken the liberal approach. because he may sit in the armchair of the businessman and take the decision. In the commercial case, my lord, he would have, his lordship would have. That is my respectful submission. So lordship, kindly allow me to share the judgment of the Supreme Court in.
So before that, you show the order which you challenged in the writ petition.
Yes.
27th February.
Page 252. Last paragraph.
Before that, my lord, kindly take, yes, that 252, even they have not incorporating the section under which section they have passed the order. I relied upon several judgments over there. There's a Madras High Court judgment on that point, Karnataka High Court judgment, and one tribunal judgment also, my lord.
তোমার এই কপিটা ঠিক আছে?
হ্যাঁ, আমি সেই জন্য একটা করে নিচ্ছি, দেখো
আমাদের দাও না।
আমার একটাই আছে, দেখো ঠিক আছে, নো প্রবলেম।
একটু আসুন একসঙ্গে করে দিচ্ছি, জাজমেন্ট গুলো আছে।
As 253, I relied upon the several judgments, my lord. They allowed the VAT.
Judgment language 246. Judgment is a bad.
Have you got a clear copy of page 253?
My lord, may I hand over? I have the one copy. I am sorry.
Because nothing is clear.
Judgments. You don't have any. Yes, ma'am. I'm sorry, there is some marking of pencils.
Now, the show cause notice was issued by the state tax authority.
Yes, but they have not.
Enclosing the verification report of the central authority.
Right. Yes.
And you gave objections. You relied upon about 7 judgments.
Yes.
And that objection was sent to the central authority.
Yes.
And did the central authority give you a hearing?
No. Several times I requested that page at kindly consider the page.
But is central authority a party in this?
Yes. I've served the
They are
copy.
very much
Mr. Uday Shankar Bhattaji was appearing in the before the read court. I served the copy to him also, that appeal petition also.
Because we have to, if you have to succeed, then the central authorities
This is
order of rejection or disallowance.
Yes. And 250 mile
27th February 2023 has to be set aside. If that is set aside only, this order.
That mail through a mail.
Where is that email?
Email, all it is indicated in the order itself, in the 27th. That email has not been shared to us. It is the state authorities.
The representative appeared as so.
Through email they have confirmed.
21 ফেব্রুয়ারিতে ওরা কপি পেস্ট করেছে আমার।
Where you furnished a copy of that report of the central authority?
No, it has not been furnished to me. I asked them. That a letter 250, my lord, kindly. I have written a letter. When I have got aware about the draft, immediately I approached to them. They kindly allow me. And before that we met with them. I requested them at page 250, second paragraph. As stated in the meeting, the reason stated by you in the report objecting the carry forward of the Senvat credit of filing TRAN is against the basic provision of the Finance Act 1994 rules framed thereunder. This was probably explained to you at the time of the meeting with request to review the report submitted earlier to the state GST department. We understand that the legal position has been properly explained to you, and there was no material on your part of the state that our submission was against the provision of the Act and rules. But you have been adamant, and there will not be any relook into the matter, even if the report submitted by you in erroneous. We also take the strong objection in you not accepting the written submission produced by us at the time of hearing today. Scanned copy of the detailed submission against the matter stated in your report is attached here with the plea that the report submitted may be relooked in the light of the facts and legal position stated in the attached submission. Now, we may also submit that we have not been provided.
They should have issued a show cause notice.
They have not issued any show cause. They have stated.
But where is Mr. Bhattacharya? Tapan Bhaja was on record.
No, Mr. Bhattacharya was appearing with Mr. Ayunobaraha.
It is my affidavit of service, my lord.
Mr. Bhonjo was not there.
So you have to get him because that is the basis of
they are the answering respondent.
They are the answering. They are acted as a post
yes,
office.
That just I think machinery.
Post office.
Post office.
And what are those judgments? 7 judgments. 7 judgments you referred.
Yes, I have relied upon 3 judgments. I am showing mine because Karnataka has been relied upon by subsequently on a Madras, and I am showing.
And you also file a clean copy of this document. Page 252 is not legible.
But a rough copy.
Para 3 onwards, para 2, 3, all are relevant.
See, this is on the merits of the matter.
Yes.
If your first ground is on the question of violation of principles of natural justice, etc., then if you are able to succeed to convince us, matter has to go back.
Yes, I am also asking for that. This is really I am sorting. And there is a judgment of our division bench also. If the relevant judgment is not been considered by the authorities, also the gross violation of the principle of natural justice. I have brought this judgment on.
All right, you bring Mr. Udaya Shankar Bhattacharya, the learned advocate for the appellate, is directed to serve. Mr. Udaya Shankar.
I already served.
Served on the department.
Sir,
informed. Not informed Mr. Udaya Shankar Bhattacharya, learned standing counsel who appeared for the respondents 2 and 5. Who will be the answering respondent, the present appeal. We'll take it up next week.
Yes, Tuesday
under the same caption.
It may be advanced position of the list, my lord, as matter may.
But the central authority does not give reasons for.
No, not reasons. They have not shared any report. Only that report had been shared by the state tax authority in a letter. After that, I approached both the authority that it is incorrect. It is not permissible under the law. Please hear me.
But what is the reason for disallowing?
So they are saying that your registration, you have not opted the registration. It is not required at all. When I raise the bill upon the creditor within 30 days, I am required.
There is one Madras High Court decision also.
Yes, I have enclosed in the petition itself. Because I have given with the written notes. So that is I have enclosed the entire thing in the petition.
I think the appeal against that order was dismissed by Supreme Court.
This against the Madras High Court. I will check.
I think it is Justice Rajiv Shagdas.
Yes, my lord, yes.
In fact, we followed that when we are in court 16, when we are sitting in the second floor.
Yes, grateful, my lord.
Serial number 6.
I did not hear for the.
Lordship, in this matter, Ms. Pona Rao Choudhury appearing on behalf of the appellant's Lordship. She has engaged in court number 19. I am praying for only not today, Lordship.
Affidavit in opposition file.
I have already started.
Affidavit in opposition has been filed by the learned advocate for the respondent. It is taken on record. At the request of the learned advocate for the appellant, list on zones. On
Monday.
When it will come, Deepesh? Not Monday. Next Friday.
Next Friday.
Serial number 7.
Even may I please, Lordship, I am for the petition.
You are for union of India.
Read petition. My lord, what happened in this case? My lord, I participate the CAPF recruitment process for 2024. My lord, I qualified the written examination. Thereafter, I called for the physical standard test. In the physical standard test, my lord, I could not, my lord, fulfill the minimum criteria for height measurement. My lord, thereafter, I preferred appeal. The appeal has not been considered through email because on the date I was restrained. My lord, on this ground, your lordships has already passed an order in 2 matters, my lord, to directing the respondent authority
So
to
one
consider.
post has been kept vacant.
My lord, 1 post has kept.
Interim order is there.
My lord, and just now I have received
Then we
this.
can do one thing. Why don't you consider their appeal petition?
Right now, my lord, I have no latest information, my lord. So, my lord, you can, your lordship may pass usual order, my lord.
So please show that.
Yes, that order is. This is the 2 orders your lordships pass in different 2 matters. আমি তোমাকে নাম্বার দিয়ে দিচ্ছি, আমি 2টো কপি এনেছি, your certificate একটা কপি। Your lordship directed the respondent authority to consider my appeal and directed me also to serve the fresh appeal along with the other.
No, in this case, I think in one of the cases you had participated in 2 earlier.
Earlier 2 stages I have.
Here, what are the facts?
Here, my lord. Here, my lord, I have not participated in any earlier process, but I have the government from government hospital. I measure myself prior to participating my examination that has shown that I have been 170.3 centimeter. Page 53 of my application. Last page, page 53. Last annex.
170.3.
170.3.
But the problem is they will not accept this.
Yes, that's right. They will not. They can measure me further in any other examination center or the appellate.
All right. This writ petition, this appeal has been filed by the writ petitioner, praying to set aside the order. On what date interim order was granted?
26th February, I think, my lord. My lord, I am not recollect my memories, my lord.
No, there is no interim order.
No interim order, my lord.
You produce the copy of MAT 2267
Yes.
before the division bench. The division bench directed you to hand over one copy to Mr. Mondal.
Yes, yes, my lord. I can recollect. My lord, in Harun Mia case, there was a
This intra-court appeal has been filed by the writ petitioner challenging the order dated 4/12/2024 in WPA 27757 of 2024. The said writ petition was filed by the appellant to seeking appointment. What was the post?
Posted constable within bracket GD in Central Armed Police Forces examination 2024.
Constable within bracket general duty.
Constable, we can fill the discussion.
What did he say? Seeking appointment to the post of constable within bracket general GD in the central force by directing and by permitting the appellant to be present before the appellate authority for remeasurement of his height. According to the appellant, his height is 170.3 centimeters, whereas the authorities have rejected the appellant's candidature on the ground that his height is 169.4. The order of rejection permits the candidate to file an appeal to the appellate authority on the same day through the presiding officer. It is not in dispute that the appellant did not prefer the appeal on the same day, and the reason being that there was a large gathering of candidates and the appellant could not approach the authority, presiding officer, to forward his appeal petition. Therefore, the appellant sent an appeal petition through email on 8th November 2024. About 10 days, about 15 days after the rejection, this appeal is stated to be pending. Though it may be true that the appellant did not file the appeal petition before the appellate authority on the same day, the court can take judicial notice of the fact that when such recruitments are conducted, there's a huge gathering of candidates, and at times law and order at times leads to law and order issue, and it will be very difficult for the candidates to approach the presiding officer to exercise the appellate remedy. In any event, the appeal petition has been sent by email, and proof thereof has been annexed in the appeal petition, in the annexures to the appeal memorandum. Under similar circumstances, this court had considered two other matters in FMA number 886 of 2025, dated 19/6/2025, and directed the appellant therein to file a fresh representation enclosing the copy of the appeal petition sent by email as well as a copy of the order, and a direction was given to the sixth respondent therein to consider the appeal on merits within a time frame. The respondents have also the Deputy Inspector General within bracket Principal Staff Officer has filed the affidavit in opposition on behalf of the respondent. wherein it has been stated that the appellant failed to file the appeal petition on the same date. Along with the affidavit in opposition, the annexures have been enclosed, including a compact disc justifying the decision taken by the authority that the height of the appellant is only 169.4 centimeters. This court is not inclined to make any observations on the merits of the matter, as it is for the appellate authority to take note of the claim made by the appellant. Therefore, we dispose of this appeal by directing the appellant to submit a representation to the appellate authority. Who is the appellate authority?
Well, the appellate authority now become functus officio. Respondent number 6 is the nodal agency who conduct all those.
Appellate authority to the competent authority, namely the sixth respondent. And the appellant is directed to enclose copy of the appeal memorandum and any other document by which he claims that his height is more than 170 centimeters, along with a copy of this order. And on receipt of the same, the competent authority shall consider the appeal petition on merits in accordance with law within a period of 3 months from the date on which the representation is submitted. The decision that shall be taken by the competent authority shall be communicated to the appellant by registered post / speed post. It is made clear that this court has not gone into the merits of the matter, and it is for the appellate authority to take a decision.
Affidavit in opposition.
That we are recorded.
May I get back the copy of the judgment? But one copy your lordship can take, my lord.
The next matter, your lordship, I was to file my affidavit in opposition, your lordship. I've served my other side. He's my other side, your lordship. So, lordship, now the reply is to be filed.
I'm not. You want to file?
I'm not there. I'm appearing on behalf of the next matter, my lord.
You file. You want to file reply?
My lord, I am not gone through the opposition till now. Just now she handed over.
Affidavit in opposition has been filed by the respondent, copy of which has been served on the learned counsel for the appellant, who seeks time to get instruction in the matter. Next week.
Lord, one indulgence may I seek, Lord?
I'm ready.
Item 10, Mr. Tiwari is for the appellant. I am for the Indian Museum authorities. Lord, perhaps today after 2 p.m. there has been a resolution taken by the bar. Lord, Monday have some personal difficulty. May it be on Tuesday. If your lordship,
My lord, may I humbly pray one thing, my lord? On the basis of the order passed by this honorable single bench, a disciplinary proceeding has been initiated against me, my lord. Let them not to proceed any further.
No,
till
that cannot.
Tuesday we will see.
Huh?
Tuesday.
Tuesday.
Same position.
10 Tuesday. I'm so grateful to your lordship, Lord.
Grateful.
Try করে
ওর জন্যই ট্রাই করে